land must consist of immovable property, land, fixtures, or fittings. Okay, the proportion is not important. You may just have a small piece of land worth 20,000. So what? It is still immovable property. Okay. Please take note also that the debts of the deceased, are not to be deducted. So if the what we call the person who has passed away owes people money, it doesn't take into account the value of the estate. The value of the estate is the value at the point of death. Without taking into account whatever taxes or debts owed. Okay. So if anything is above 2 million, you apply the Distribution Act. Anything is below 2 million, you apply the Small Estate Distribution Act. Okay, it's a very simple equation. Okay, I hope you can remember that the value must be added between the movable and immovable property. Add them together, you get a total, and then decide whether you apply the Distribution Act or the Small Estates Act. Okay, very simple equation. Our main concern today is the law of Islamic succession. Now, the principle is actually very simple. You'll be shocked how simple it is. Okay, the only thing that is complicated is when you decide to mix them up together. Okay, and the examiner likes to mix it up together. They're now going to give you one question on Fara'if, one question on Distribution Act, and keep it separate. For the most part, the examiner would like to mix things together, okay, to test your knowledge on which to apply. Okay, so one person may be non-Muslim at the age of 20, suddenly becomes a Muslim at the age of 30. Is he or she entitled to the device or the bequest under the will of a Muslim or of a non-Muslim? Okay, so you have got to be very sure of the principles. And this semester, you have only 3 hours to do your paper. You don't have the whole day to go and do your own research. Okay, you either know your stuff or you don't. Okay, and because they're going to mix things together, or rather because John Chua is going to mix things together for you in the finals, you have got to understand the most basic principle of them all. The most basic principle is the case of Rikima Abdullah. In the case of Rikima Abdullah, Japanese woman converted to Islam, and then she doesn't know the law of Fara'if. So Gordon Smith J, yes, this is a British judge deciding on a Sharia case. Okay, it is not a Muslim who has decided it. It is a Masaleh. Okay, he made it very clear that only a Muslim can inherit from a Muslim. A non-Muslim cannot ever, no matter under what circumstances, inherit from a Muslim. Okay. On the other hand, if you are a non-Muslim, you have a property to give away upon your death. The distribution of your estate can go to anyone, whether it's a Muslim or a non-Muslim. Okay. So if you have a testator who is a Muslim, everything must go by Fara'if. There is no more Distribution Act, no more Wills Act. If your testator or testatrix is a non-Muslim, then you have to be indulged only in the Wills Act and or the Distribution Act or Small Estates Act. Okay, so this is where the division comes in at the very beginning. If you're a non-Muslim, you can give your property to anyone. If you're a Muslim, you can only give it to a Muslim. So that is the case in Rikima Abdullah. Okay, I think it is the same as Majlis Agama Wilayah versus Lim Yi Seng, the case right in front of you. Here, the deceased has again embraced the Islamic faith. And unfortunately for him, he did not know the law of Sharia. Okay, so his wife and the daughter were still non-Muslim. They didn't know. So the court made it very clear, the local courts, that if you are non-Muslim, whether you're the son, daughter, or even the direct bloodline, you cannot inherit. You cannot inherit. So the property went to the state. Okay, went to the state. Federal Territory Islamic Council. Okay. Okay, I've done these two cases. Okay, perhaps you would like to look at the top part of this slide. This book is written by N.J. Coulson, again a Matsali, writing on Islamic law. Okay, you will be surprised how much the Matsali knows about Muslim law. But it's a very old book, 1971, at page 218. It makes it very clear this is a secondary, not a primary source of law. Any adult Muslim who is sane and of free consent can make a will. Now, under Islamic law, unlike civil law, a will can be made verbally or in writing, or even by gestures. Gestures meaning sign language. Now, under the civil law, under your Wills Act, I hope you have a copy of the Wills Act. Under your Wills Act, a will is only valid if it's in writing. They cannot accept oral will, and they cannot accept a will by gestures. But Islamic law is more flexible. It can be in writing, it can be verbal, it can even be by sign language. Okay. In other words, an Islamic will or wasiat need not be attested, need not be even signed. Okay. So that is the primary difference between a civil will and an Islamic will. Execution in writing is not required. However, look at the second paragraph. The subject matter of the will. Subject matter of the will means the estate. The estate, whatever you want to give away, is called the subject matter of the will. Cannot be something which is haram. So you cannot give away, I don't know, your wine or your liquor, whatever that is haram under your Islamic law. Under civil will, you can. Okay, you can. So this is another conspicuous difference between the Islamic will and the civil will. Okay. Latifa's case, Latifa binti Rosmawati Shariban, 2000. Okay. Now, in this case, the question arises whether specific forms of asset forming the estate of a deceased person who is a Muslim, okay, here the petitioner petition for a letter of administration. Letter of administration, as I've explained earlier, is when you don't leave behind a will. Okay, if you leave behind a will, the petition will be for an order of probate. If you don't leave behind a will, it is a petition for the letters of administration. In a probate, an executor is appointed. In a letter of administration, an administrator or administratrix is appointed. Okay, this is just for your general knowledge. Now, the question before the court is actually very simple. Okay, whether a gift which is done inter vivos, that means the person is still alive, is subject to the law of Islamic succession. The answer is it is not. Okay, so whatever that you have given away while you are alive as a Muslim, you cannot later transact under the law of Sharia. What is given away inter vivos no longer forms part of the Islamic estate. So this is the same as civil. This is the same as what we call the Sharia law. Okay, it is the same on both ends. Okay. Let me see if there's any other case here. No. Majlis Agama, we have done this. Simple. Abdul Wahid's case, yeah, aka Lim Sek King. This is a case whereby the man, Abdul Wahid Lim, converted to the Islam faith, and he did not inform his family of the same. And again, he doesn't study Sharia law. So he didn't leave behind a will when he died, and he left behind a wife and 3 sons. Again, they are all non-Muslim. Something like the Mukima Abdullah's case. Okay, the eldest son had a very a rare disease and takes a lot of cost for his medical. And the widow, the wife, had to take 3 jobs just to raise the children. Very sad case. So they were fighting very hard for the property. The court said, no, you are non-Muslim, you cannot get the so-called property. The law is very clear. No matter how sad the situation is, you cannot get it. But the Malacca Islamic Religious Council, we call it MAIB, was very, how should we say, generous on this occasion. They knew the suffering and the plight of the widow and the difficulty she had raising the children. So they donated half of the estate to the non-Muslim family. Despite the fact that they were not entitled to anything, they donated 50% to help out the poor widow. Okay. Okay, before we go into the specificity of wasiat, some general rules needs to be observed. Okay, I've summarized everything here for you. So before we go into that, there are still a few cases which I need to discuss with you before we go to the general principles stated here. Okay. Now, Siti Yatim's case versus Muhammad Noor Mujali. Burton J, again, another Masaleh case doing Sharia law, makes it clear that a will of a Muslim which intended to give an heir bigger than his share is considered invalid, okay, without the consent of the other heirs. Now, what do you mean by this? Let me see if I've got a book. I've got a piece of paper. Okay. So, Islamic distribution of property is actually something like this piece of paper. Let me admit one more student first. Okay, it's like this piece of paper. You divide it into two sections. Okay. On one section, you will call it the legal heirs. Legal heirs means somebody directly connected to you. Okay, who are the legal heirs? The best way to explain the legal heir is to look at the jadwal. Hang on, let me find the jadwal. Yeah, this is a jadwal. A wife is a legal heir, a son is a legal heir, a daughter is the legal heir. Okay, a husband is a legal heir. Anyone else? A father is a legal heir. A brother, a sister, a mother is a legal heir. Okay. Outside this, they are non-legal heirs. Okay, so the rule of distribution is actually very simple. No? If you are a legal heir, you are entitled to 2/3 of the property. If you are a non-legal heir, bukan waris, they call it bukan waris, you are entitled only to 1/3. It cannot be more than 1/3. That's why we call it the 1/3 rule. So if your property is 1 million, only 1/3 of that can be given away to Muslim, can be given away to Muslim. This portion is given to bukan waris, not waris. Waris is entitled automatically to 2/3. Can you give away less than 1/3? Yes. Can you give away 1/3? Yes. Can you give more than 1/3? No. Okay, let me repeat that. Can you give away 1/3? Yes. To who? To bukan waris, non-legal heirs. Can you give less than 1/3? Yes. Can you give more than 1/3? No. Very plain, very strict, very simple. Nothing complicated there. Question. What if I want to give more than 2/3 to a legal heir? Can I do it? Answer yes. What do I need? I need the consent of the other legal heirs. When? After the death of the testator. After the death of the testator. Can I give more than 1/3? Yes. What do I need? Consent. From who? Waris. When? After the death of the testator. So the formula is as stated. Yeah? Okay, the case of Amanullah versus Hajjah. I can't see clearly from here. Hajjah Jamila. Hajjah Jamila. Here, long, complicated story. Let us cut short to the judgment. Testator here was in a coma. Okay, the judgment is explanatory of its facts by itself. Testator was in a coma, very ill, and the court said if you are ill, you cannot make a will. It's the same as the civil will. Your wasiat is invalid. Why? Because you do not have what we call animus testandi. You do not have animus testandi. The intention and the awareness to write a will. If you don't have the awareness, the free consent, and of course, the intention to write a will, your will be void. It is the same as civil. It is the same as Sharia. No difference. Okay? Now, more importantly is the one I've highlighted for you in yellow. Even if the will is validly made in this case, i.e. it has animus testandi, the will still be invalid because it purported to dispose more than 1/3. Remember, the limit is 1/3. More than 1/3 to the whoever that it wants to distribute. Whether it's legal heirs or non-legal heirs, it cannot be more than 1/3. Further, there is no consent. There is no consent given by the so-called waris, okay, the legal heirs. Okay. I pose an interesting question at the bottom. Here, consent of the legal heirs is imperative. But what if there are no legal heirs? So that is a question I want you to go back and think. I'm not going to give you the answer straight away. Okay? Zalani Bongsu is another case which you might want to take note versus Bahrum Othman and Zaitun. Very long name, the case. Now, here the so-called deceased is a Muslim. The deceased, a Muslim, had some property. The property was charged to a bank, and in due course, because the loan couldn't be paid to the bank, the property was sold off by the bank. Lelong, we call it lelong. Okay. Now, according to this case, the court said it that whatever that has been sold off can no longer be subject to the law of fara'if, because it is no longer the property of the deceased. Okay. Number two, citing Amunullah's case, the will was invalid because he was a Muslim and he cannot give away more than 1/3 without the consent of the legal heirs. Further, here, whatever he wanted to give can no longer be given because it was already sold off by the bank. Okay, so that is in essence Jalani Bongsu's case. So the two-third distribution rule has its own what we call formula, just like your Distribution Act. The formula is given to you here all. I shouldn't be doing this, it's spoon feeding my student, but give you all a chance to get everything on a silver plate. Okay. So I don't have to read through this, you can read through it yourself. Okay. The main jadwal starts with this. So example is this. If a person dies, leaving behind a wife and no relationship, no relations, no other relatives or children, the wife will get 1/4. The rest will go to the state. Okay? If you leave behind a wife and a son, 1/8 will go to the wife, the rest will go to the sons or son in equal proportion. If you leave behind a wife, a daughter and a son, this is the formula given. And so forth and so forth. Okay, so all the formula is here. All you have to do, if you get a question, is to work out the maths. Everything is given to you here. It's very plain, it's very simple. Yeah, father, mother, you can give it to your father. 2/3 to the father, 1/3 to the mother. So what should the mother do to the father? I don't know. You get his share. Yeah. 2/3 rule. Yeah. In the event it is not in the jadwal, you follow this 2/3 distribution rule. This 2/3 distribution rule is actually also quite simple. So an example is very simple. If you leave behind no parents, no spouse, no issue, then it will go to your brothers and sisters who will share the estate equally. Okay, half-half, 50-50. If you don't have any brothers or sisters, then it will go to your grandparents. If you have no grandparents, you will go to your uncle and auntie. If you have no uncle and auntie, you will go to your great-grandparents. If you got no great-grandparents, you will go to your great-granduncle and great-aunts. I don't know how many of you got great-grand-aunts and grand-uncles. Huh? If you still don't have anybody, then you will go to the government. You will go to the king. Okay? But that will be a very sad case. Huh? In the event you live your life on Earth, in this planet for how many years, and you leave behind nobody, there will be a very sad day and a very sad case. So in simple English, get somebody. Get somebody. Okay. I'm almost done here, but the most important is this page. Okay, this is where all the principles